Welcome to Disunion, the Government Union Report, the podcast where we delve into the ever-evolving landscape of public sector labor policy and law. I'm your host, David Osborne, and I'm excited to be your guide through the complex world of government unionization. We bring in experts and individuals with hands-on experience navigating the challenges and opportunities surrounding the unionization of government employees. From the latest legal developments to the practical insights that shape the policies, we've got it covered. So get ready to gain a deeper understanding of the news-making issues that impact public sector labor policy across the nation. All right, my guest today is Andrew Holman. Andrew Holman is a policy analyst here at the Commonwealth Foundation. And things are a little bit different today. Usually I have an external guest, but Andrew is joining us here from within the Commonwealth Foundation because he and I have long worked on this product called which we refer to often as the State Labor Report. It is actually a report about all 50 states, but it's just about their public sector labor laws. And for each of these states, we assign a grade, anywhere from F to an A. Do we have an A plus this year, Andrew?
We do, yep.
An A plus. And every other year we put out this report. We've had a couple of movers over the last couple of years that you'll be able to see as soon as we release this report. Should be a little bit later. We're recording this on the week of August 26th. Should be later this week. So the way that Andrew and I have formatted this will be a little bit different than I've done in the past where we have a guest. I asked Andrew before the podcast to come up with his top three, basically things that he's learned as a result of doing this report. I've got my own top three. Together we have a top six. And so we have our top six interesting things that are coming out of this report. And we're going to do this draft style. We did a coin flip and Andrew won the coin flip. So he's going to be going first here. He's going to give us the number one takeaway from this year's report. And we'll go back and forth. So without any further ado, Andrew, what was your number one, your Peyton Manning top one takeaway from this report?
Well, yeah, thanks for having me. I'm a Patriots fan, so not a big Peyton Manning guy. But we'll let aside. My biggest takeaway from this report has to be from the state of Michigan. And I think Michigan really showed that no matter how good your state is, everything can change in one election cycle. I've always looked at Michigan as sort of a leader on public sector labor law. I know they were one of the first, if not the first, to do paycheck protection and some of those other reforms. And all of that got undone in the past 2 years. So, like I mentioned, they undid their paycheck protection laws, which means that unions are now able to collect dues and fees through the public payroll system, something that they previously prohibited. And as far as I know, they're the first state to actually overturn that legislatively. I know Missouri and maybe a few other states have had reforms that got blocked through the courts. Michigan, to the best of my knowledge, is the first one to actually overturn that legislatively. So in that sense, they undid a lot of the good. And then they also ushered in a lot of the bad. We'll talk about this a little later. They passed some legislation that allows unions to access employee contact information. That one's really bad. They expanded bargaining for public school administrators and some grad students. That's something you're seeing in a lot of the deep blue states where unions are trying to expand their power and kind of mitigate the post-Janus losses. But what I really wanted to talk about was around their right-to-work law. I think it made a lot of headlines when they overturned their private sector right-to-work law, but I don't think it made a lot of headlines when they instituted what I've been calling a fair share fee trigger law. Now, these trigger laws, this is something that you see across the country in different areas. I think the most prevalent one is with abortion. Several states had, before the Dobbs decision, trigger laws that said, if Roe's overturned, this will happen. Now, Michigan did this with fair share fees. And, this is also something that I see in contracts. I did an analysis of Pennsylvania teachers' contracts 2 years ago and found something like this in about 20% of contracts. Basically, the language says something like, based upon the Janus decision, both parties are aware that unions can't require employees to pay fair share fees. In the event that fair share fee is, again, deemed legal, the following provision will apply. And then it has the typical fair share fee language. Now, what Michigan did is put this in state law. And it basically says, if Janus is ever overturned or if the United States Constitution is ever amended to permit this, Michigan will automatically permit fair share fees.
Yeah, okay. So I like that. Strong pick. This is a big takeaway that things could change in a year. I want to make sure that our listeners understand the idea behind this trigger law. So right to work, people often talk about right to work, but what they really mean is it a labor-friendly or a labor-unfriendly state, with right to work being unfriendly, supposedly. All right to work really means is that a union, when they come in, they can't charge non-members a fee as a condition of employment. Obviously, the union will have its members, but these fair share fees are requirements for non-members to have to pay to keep their job. Right to work would prohibit the imposition of those fees. In the public sector, the Janus versus AFSCME case has basically said that you cannot do that anymore. So right to work basically in every state across the country for the public sector. This trigger, I think I remember, but I'll put you on the spot because you made the pick. What is the trigger? What would have to happen before fair share fees are finally legal again in Michigan?
Yeah, in the statute that they enacted with this trigger law, it was either if the Supreme Court makes a decision that overturns or somehow overrules the Janus decision, or if there is a amendment to the United States Constitution.
I thought I remembered that. So I think that's, a very unlikely event.
Yeah.
But if it happens, I guess they can charge fair share fees in Michigan public sector. All right, very strong. My pick is strong, I think, as well, but for very different reasons. So I'm going to pick Florida. Florida made a ton of worker-friendly reforms over this past couple years. And, it's surprising in a sense because Florida had already done quite a bit for workers. And in a minute, I'll explain what I mean here. But one of the things that's remarkable about Florida is that they continued to enact worker-friendly freedoms, even though they had done it in the past. And having worked with a lot of legislators on union-related issues in the public sector, the thing I often get from legislators is, haven't we done this before? Or didn't Janus take care of that? Or something to that effect. Are we done with labor? We don't have to keep looking out for employees anymore. Well, Florida's evidence that, yes, you do. And when you do, you actually get some amazing results from it. So in Florida, just a few years ago, they enacted something that I'll call recertification. I'll call it that because Scott Walker called it that in Wisconsin years ago. The basic reform is that you ask workers periodically to recertify or reelect their union officials. The norm across the country is that public sector employees don't get to reelect their unions. Once they're in, and that can be all the way back in the 1970s, they basically hold their certification or their right to represent a group of workers forever. And the only way to get rid of them is a decertification process, a process of removing them. It has to be a grassroots movement by a bunch of workers who really have to meet after their working hours are over on their own time. And they're often going up against the union that's trying to keep their job. So as a result, decertification is a very unusual event. It's a legal event that they're often trying to navigate without lawyers. So recertification would basically put the onus on the union to reprove itself and to give workers this automatic opportunity to vote their union out if they don't have support. Florida enacted that reform and basically made it contingent on if the unions lack 50% membership on any given basis, then they have to run for re-election through this recertification process. Well, this past year, Florida upped that number from 50% to 60%, so that a union with membership falling below 60% will have to stand for re-election. That's a fantastic reform. One of the major improvements, though, was not just the number, but how the union has to prove that it has a certain level of membership. Previously, they had to do that based on self-reports of their own membership. This self-reporting number was often, there were some issues surrounding it. One of the big reforms that Florida brought to this was that unions would have to file registration every year to report to the equivalent of the labor board. It's called the Public Employee Reform Commission, or PERC. That would have to file documentation to prove that they had this kind of membership. And it would have to be certified by an accountant. So the accountant's going to have to look at that information. It's a pretty big chunk of information so that PERC can make that call. And once PERC says, your membership has fallen below this number, then the union has to run for re-election. So it sounds kind of complicated, but in the end, it's an opportunity for public sector workers to vote for or against the union that's supposed to be representing them. And what we found out through that process is that a lot of unions really have never had the support internally to be able to stand for re-election. So if you go to the PERC website right now, on Florida's website, Florida's, whatever it's called, Florida, PERC.gov or whatever, then you'll see that many unions are losing their certifications, not because they stood for re-election and have lost the re-election, but because they just declined to file the paperwork altogether. Some big articles about this came out recently that alerted me to it. It's the only reason I went on the website and started looking, and it turns out it's happening all over the place. Unions all over the place are losing their certification. That wasn't the only reform, but those are the biggest reforms in Florida that I think have made a big difference for public sector workers. The unions that purported to represent them with all of the legal authority of a union that represents over a majority of the bargaining unit actually don't have it, and now they're gone. They're losing their certification. I think that's fantastic for workers because now workers can either find a union that represents them, which I'd fully support, or they can represent themselves in a sense and wouldn't have the union in the way.
Yeah, absolutely. Great pick. I did have one question about Florida and their approach to recertification. I think it's kind of novel, their recertification on the basis of membership rate. I know in Iowa and Wisconsin, they actually do it in regular intervals, whether it be 1 or 2 years, where the union has to stand for election at regular intervals. What do you think about Florida's approach and kind of the impact that it's having versus Wisconsin and Iowa?
Yeah, so Wisconsin and Iowa were the only ones that have recertification. Yeah, they do it on a regular basis. It depends on your state. I mean, I think there are a lot of reasons why the regular thing works better because you don't have to go through all of this. I mean, Florida had to fix what was broken from a few years ago. They didn't have the numbers to support this 50%, 60% thing. So in that sense, Wisconsin and Iowa were better in that they were just automatic. What's unfortunate about those states, and what I think if you're in another state that wants to see this reform happen, what you might have to contend with is a labor board that really doesn't want to go through all the work. So if they've got to run a re-election like every year or every 2 years, and they've got to do it for every single bargaining unit, which is what Wisconsin does, then, boy, it's going to be a lot of, at least your labor board is going to think it's a lot of work. I've talked to the folks in Wisconsin, though, and I've asked them, was it a lot of work? And they said it was the first few years, but after they got into the swing of it, and after the unions that were obviously going to lose a close election were out of it, then now they're dealing with, very few unions lose their certification elections in Wisconsin. Iowa, very few have lost from the very beginning. It's just most unions have gotten the idea that they've got to prove their value to their unions going into the election, just like an elected representative would.
Yeah, I think it's great, especially that last point you mentioned about the union having to prove itself to the workers. I think that's important.
All right, round 2, Andrew. What's up next?
So this is a bit of a outside the box pick. I would like to talk about the union membership numbers. That is my second pick. So we took a look at the 4 largest government unions, that is the National Education Association, the American Federation of Teachers, Service Employees International Union, and the American Federation of State, County, and Municipal Employees. And we looked at their self-reported financial forms, the Form LM2. And on these forms, they report their membership numbers. And part of this report every year is looking at how those membership numbers have changed, and this is taken on particular importance after the Janus decision. So this year, the updated numbers, we found that since Janus, these 4 unions, NEA, AFT, SEIU, and AFSCME, have lost over 380,000 fair share fee payers, which makes sense after Janus, if you're paying a fair share fee, and then all of a sudden you don't have to, you're probably not going to continue paying that fee. And in addition to that, we found that they've lost 320,000 members. These are, they are with 320,000 less dues paying members. And that's significant. We did a quick calculation and found that together the fair share fee payer and the member losses have an estimated total annual financial impact of $106.8 million. That's a lot of money. That's a lot of people. And you're seeing that these unions take a hit. Comparing pre-Janus reports to the most recent reports, SEIU's dues revenue has dropped by about $37 million. AFSCME's has dropped by about $3 million. NEA's revenues are up, but they sold $135 million in securities last year. And AFT's dues revenue are down $7 million. And what these financial impact numbers don't really capture is the impact of increasing dues to make up for these membership losses. And that's something that we've seen as the union's membership numbers are dropping, they're actually increasing these dues to help cover those losses. And then that also gets into some of their new organizing tactics, like we saw in Michigan with public school administrators and grad students, where they're trying to reach new employees to offset these losses.
Yeah, we had at the very beginning of the report talked a little bit about how the loss from Janus is part of what's driving some of the new legislation, which a lot of it seems geared, like you're saying, to increasing membership. Because if you can no longer recoup fees from non-members, you better increase membership somehow. Sometimes they can do that. The best scenario for me would be if unions were to focus on proving their value, much like recertification, and get some of those members back. But unfortunately, there are easier ways to increase membership. One is capturing these broad new workplaces, and then another one is pressuring workers into joining through things like orientation sessions, one-on-one recruitment, and obtaining worker data. So that's good. In a way, that's a top draft pick. You got to steal in the second round.
Thank you. And just one other thing that I want to mention, you'd expect to see an acceleration in these membership losses, like right after Janus happened. It's on the top of everybody's mind. But we're actually seeing these losses continue to happen. Just over the past 2 years alone, the four unions have combined to lose over 100,000 members. So this is something that is continuing to happen and is going to continue to be a problem for these unions.
Yeah, I'll add too that you're talking about loss in membership. There was also a loss in government, especially in some of the more progressive states during COVID, where some government work was just cut. And so the raw numbers are maybe falling in addition to the loss of just the overall pool of state workers.
Yeah, absolutely. And that's definitely something that impacts their bottom line as well.
I'm going to pick another state here. I'm picking Illinois. Illinois did something that I found surprising. Maybe I should have seen it coming. But Illinois, over these past couple years, adopted a constitutional provision that's called worker rights. And it was known during the election as Amendment 1. It is now Article 1, Section 25 of the Illinois State Constitution. And I'm not going to read the whole thing, but it's important to get the verbiage in. The first sentence says, employees shall have the fundamental right to organize and to bargain collectively through representatives of their own choosing for the purpose of negotiating wages, hours, and working conditions, and to protect their economic welfare and safety at work. Those are pretty stunning words that will create a real change to, we've examined in our report the statutes, but really this, because it's a constitutional provision, is going to take precedence over any statute in Illinois. Not just labor statutes, but all statutes. And in fact, the rest of the amendment is very clear. It says, no law shall be passed that interferes with, negates, or diminishes the right of employees to organize and bargain collectively. Keeps going. So what this amendment does on the ground is it invalidates any existing law in Illinois that would somehow, I'll use the words from this amendment, interferes with, negates, or diminishes collective bargaining. And then any law going forward, let's say the legislature doesn't like, how far this has gone, the impact from this particular amendment on state law, they would not be able to fix it without another amendment. So you're looking at something, remember Prohibition, Andrew. We weren't alive for this, but prohibition was a total colossal mistake. Well, Congress couldn't fix it by statute. They had to go back and get another amendment to the U.S. Constitution, something extraordinarily difficult. A little easier in Illinois, but still very difficult to do. Yeah. This has already had an impact in state law. What we've seen in bargaining between the Chicago Teachers Union and the city of Chicago, which is already trying to do the Chicago Teachers Union a bunch of favors, has been to really commandeer that process in order to get a whole bunch of progressive things done for the union that have nothing to do with the teachers and really have nothing to do with traditional public sector bargaining. So there were leaked documents that Illinois Policy Institute published just a few months ago that suggested that the Chicago Teachers Union was going to use Amendment 1 as an opportunity to demand not only, big salary increases, something you might expect, but also policy changes like affordable housing and rental assistance, all-electric bus fleets, solar panels at schools, transgender-affirming policies for students, in-school union political rallies, and even changes to the pension system that would comply with some of the ESG requirements that have been so popular in other areas and in other states. And to be honest, as a constitutional lawyer, this is the kind of thing that you could do once one has a fundamental right that no one could negate or diminish. I mean, those are broad terms that the courts are going to have to work out over the next few years. Now, I don't know. Maybe you see the courts do something with this that's not expected, but on the bare language of it, I think we've got a major problem in Illinois. For better or worse, this policy idea was adopted in Pennsylvania, and so what we saw, what was it last year, was the Democrats in the House, the state House, pass an amendment that would have to go through the Senate, unlikely to do so, but would have to go through the Senate and then do that process all over again to appear on the ballot. But they want to see a constitutional amendment in Pennsylvania, too. Similar language was introduced in California as well, so that this could be the gold standard for unions, much the way that maybe for us and for public sector workers, the gold standard is Florida right now. Yeah,
absolutely. And I think the last part that you hit on with it spreading to other states, I think that's really the scariest part of this legislation. I know, upon first read and reading a co-sponsor memo, it doesn't seem that bad. It seems like it's just affirming the right to collective bargaining.
Yeah.
But then you take a deeper dive into it, and some of the language, the fundamental right and the implications of it, and you've seen, like you mentioned, you've seen it with the Chicago Teachers Unions. It's kind of scary, that when the collective bargaining demands to read a candidate's policy platform, there's something wrong with that. You've seen it in California, seen it in Pennsylvania. I believe Vermont introduced something similar. And I think Minnesota as well. Seems like it's really catching on, and it's not good. And I wouldn't be surprised as, things continue to go along in Illinois if those other states kind of hit the brakes a little. Whoa, I don't want to get into that.
Well, I was privileged to introduce to do some written testimony for the Commonwealth Foundation when Pennsylvania was considering this. And I do think it's important, even if I'll talk to two different audiences. One, if you're a worker who's represented by a union, you're somewhat indifferent. I mean, you're not really, let's say you're not an official within the union or something like that. What you're doing is handing over an extraordinary amount of power to your union. So it reads as if these were workers' rights. But what's clear from the text of the amendment is that you have to bargain through a representative. That means your union is really the one it's really about union rights. And the union is getting a lot of power to do what it couldn't otherwise do under the statutes. You have things like unfair labor practices that are supposed to protect you as an individual employee against a union that's maybe gotten too aggressive or that hasn't done a good job for everyone in the union. Well, I think this workers' rights amendment, really union rights amendment, privileges the union to continue doing the wrong thing, even on your behalf. And so I think that's pretty scary. But second, even if I were a huge union advocate, I'd say this is not the right way to go. The union doesn't even realize what it's unleashing here. You're right. It says fundamental rights for workers. It sounds really good. That's part of the challenge in a place like Pennsylvania, where people want to do good things for workers. I mean, I do too. But ultimately, this is not written in a way that you could ever predict the outcome of what's happening. And a union that's doing a fantastic job for workers, let's say, is going to be surprised at all of the terrible unions negotiating for things like Chicago Teachers Union has done and really messing it all up for everyone. So, I think there are a lot of warnings. Thanks for that, Andrew. All right, you're up here in pick number 3. This is your last pick, so you're going to have to fill out the rest of your roster here. Go for it.
Going to have to get a lot of undrafted free agents. I think for my third pick, I'm going to go with a sleeper pick a little bit. I'm going to talk about a trend that we've seen, and that is union access to employees' personal contact information. This is something that is like spreading like wildfire in the post-Janus world of public sector labor relations. Since 2018, we've seen 14 states enact this type of legislation. And what it does is it requires public employers to furnish unions with an employee's personal contact information. This could be on the very basic level, home address, personal emails, personal phone numbers. In some states, it's gone way further to the point where you're giving employee identification numbers, the employee's social security numbers. It can get pretty out there. And what it does, essentially, is it just gives unions an unprecedented level of access to employees and makes it easier for the unions to organize these employees in support of the union's political and bargaining objectives. This is something that's kind of always happened at the workplace. You know, the union has their bulletin board, they get access to certain meetings, they can use the mail system in the school, so on and so forth. Now this is really bringing those same ideas into employees' personal lives. And I think it really hurts them in two ways. On the most basic level, it's the intrusive, unwanted attempts to get non-members to join a union, to get members to support union politics that they don't necessarily agree with. You know, you're going to get inundated with union political employees, other materials. And, you know, that's always happened, but now it's happening at home, which as a public, you know, if you're a public employee and you don't want to hear that stuff, I imagine it's got to be quite frustrating. And then the second impact of this, I think, is far more serious, and that's personal information security, particularly with cyber attacks. In the states where unions are getting access to employees' social security numbers and some of the more secure personal information, you know, that's another group that's holding that information, and they're responsible for protecting it. And not that they'd ever, you know, lose it on purpose, but mistakes do happen. And we saw in California, I believe it was last year, one of the SEIU locals out there, they were a victim of a cyber attack where they had a bunch of data stolen. And among that data was employees' social security numbers. That's a serious data breach. And this type of legislation, it opens up the possibility of stuff like that happening. So it's not only annoying to the employees, but it can also be dangerous to them.
After having litigated some cases against unions who are holding data, you know, not necessarily worker data, but just data, meetings, agenda, whatever, I can tell you it's not secure and they often lose it. So it's not unusual for this kind of thing to happen. I saw that social security numbers were actually provided for in law in Hawaii. And then to go back to the recruitment side of what you were talking about, during orientation, one of the laws that stood out was Vermont. They allow unions a minimum of 1 hour with new employees. And that can be on an individual basis, not just during orientation. But a similar provision was vetoed in New Hampshire. So this is these people still have some sense of like, it's kind of creepy. All right, my last pick is going to be. I'm trying to fill out my roster, Andrew. I'm going to kind of make a combo pick and cheat a little bit. Virginia and Colorado. So over the past few years, Virginia and Colorado have been one of the big movers, and unfortunately, it's in a union official direction. So union officials in Virginia and Colorado have long been working on getting state laws that would allow them to organize. And in Colorado, they were already pretty organized. There was a union that represented state employees called Colorado Wins that had been around for a little while by executive order, but they were looking to get security. So in both of these states, they were able to get a state law. They look a little different from one another, but they both had the effect of slowly getting incremental access to public employees, winning the right to, in Colorado, first represent state employees, and then go county and local, and then go every single county and every single school district and every single public workplace that you can imagine. Virginia did it a little differently. Virginia got a state law passed that would simply allow local governments, including school districts, to adopt collective bargaining as a general way to order their affairs with the workforce. But they would also have pushed down a lot of the responsibilities normally borne on the state, like having a state labor board or prosecuting unfair labor practices or something like that. They push all that down to the local level so that if a local government wants to adopt one of collective bargaining as a policy, they're also going to have to figure out all of these practical things like how do we set up our own labor board or equivalent thereof, or how do we prosecute unfair labor practice? How do we even recognize unions or run elections or whatever? So unions got a significant victory in both states, but it was very incremental. They moved faster in Colorado and basically have unionized potentially every sector, every workplace within the public sector. In Virginia, it's been a lot slower. And so although I thought that kind of law pushing down this decision-making to a local level would really unleash union officials all over places like Loudoun County and Fairfax, some of the more liberal areas of Virginia, is actually been a lot slower than I would have imagined. And I think that's for at least two reasons. One is that workers who have long lived without a union in their lives, they've had the union, but it's been an association that they've been part of, not a collective bargaining agent. I think they've realized that we really don't need them, especially when we've got these hyper-progressive school boards that want to give us everything that the union wanted anyway. So we can have the best of both worlds. We can have a union as an association in our life, but we can still get all the high pay without having to give up any of our autonomy. I don't think they see a real reason for the union in many of these areas. And then second, I think another feature of this has been the practical reality that the local governments are going to have to take on huge costs just to run collective bargaining. We saw some of the counties have to figure this out very early on, and some of the numbers that had come back had been, we need to hire dozens of employees and spend millions of dollars just to run collective bargaining. So I think that's actually helpful in a way. It's like a natural experiment for someone researching policy in this area, that we can see, I wonder how much money, time, and effort it takes to just run collective bargaining on the state and local level, not to mention the federal level. This is an expensive policy endeavor that is not, it's not an efficient way to run a government. So anyway, I found both of those states very interesting, and I'm interested as a researcher and someone who's interested in policy to just see what we can learn from these states, where the budgets go next, and whether workers are ultimately happy. Because, Andrew, that's one of the things we're most focused on with this report. What is this actually working for the typical worker? We call this workplace freedom or worker freedom, because that's ultimately what this should be about, both for us and for the unions.
Yeah, absolutely. And that's one of the things that I appreciate most about this report is that we do look at it from the worker's perspective. I feel like on labor issues a lot, that people tend to think worker and the union are the same. They're not. You look at something like membership opt-out windows. When a union restricts the right of an employee to resign their membership at any time, that's not pro-worker. That's pro-union. And I think it's an important distinction to make in this area with is this something that is actually beneficial to workers, or is this a special legal privilege that union executives want to enjoy?
Yeah. Okay. Well, thanks for coming on, Andrew. I have to ask you, like I would ask anybody, well, where can we find out more about your work and what's next?
Yeah, absolutely. You can find more of my work on Commonwealth Foundation's website. I do a lot of work with David. We have this report coming out. We did 2 great reports last year on union political spending and union membership in every state, so check those out as well. Also, what's next? This report coming out in the next few days, few weeks. I want to talk about the great new website tool that we have. It provides an overview of pretty much everything in the report on the website. And you can find that at www.commonwealth.foundation/state-labor-analyst.
We need a vanity URL. It's like, yeah. All right. Well, thanks. I appreciate it, Andrew. And we'll see you, later today. And that's a wrap for today's episode of Disunion, the Government Union Report. We hope you found today's exploration into public sector labor policy both insightful and thought-provoking. Special thanks to all of you for tuning in. If you enjoyed today's discussion and want to stay informed about the latest developments, don't forget to subscribe to Disunion, the Government Union Report, on Spotify or your favorite podcast platform. Your support means the world to us. I'm David R. Osborne, reminding you that understanding labor policy is crucial for shaping the future. Until next time, stay informed, stay engaged, and keep making a difference.